Hello, I'm Derek Helling, sports business and legal analyst for the Cold Hard Truth on Sports. You can find me on Twitter at @DHellingSports as well as Facebook and Instagram at Derek Helling Sports. With my shameless plug out of the way, let's talk about Ploetz versus NCAA. Ploetz v. NCAA is a case which will go to trial next month in Dallas, Texas, and has the potential to be bad news for the NCAA. To understand how and why, let me take you through the case's history and explain the implications. In 2015, former NCAA football player Greg Ploetz, that's spelled Ploetz, passed away at the age of 66. His autopsy revealed that he had suffered from chronic traumatic encephalopathy, or CTE, when he was alive. In January of last year, his widow, Debbie, filed suit against the NCAA in the Dallas district of the state of Texas. Her original complaint stated that the NCAA is liable for Greg's death because of his diagnosis of CTE and the fact that he played football for the University of Texas for 4 years. The NCAA's liability, the suit argues, stems from the NCAA's failure to educate Greg of the risk of playing football while they knew or should have known of the connection between sustaining blows to the head and developing neurological disorders like CTE. The NCAA tried to change the venue of the trial last year, but it was unable to do so, and an original trial date was scheduled for January 22nd of this year. That was delayed, however, when the NCAA petitioned the Texas Fifth Circuit Court of Appeals for a writ of mandamus in regards to discovery in the trial. So what do all those legal jargon terms mean? Discovery is the name given to the process of sides of a dispute exchanging information so that the lawyers can prepare to make their arguments. A writ of mandamus is a higher court giving instructions to a lower court in how to proceed in a trial without an appeal of the entire case to the higher court. Put more simply, just one part just one part of a suit is appealed to a higher court instead of the whole thing. It's kind of like when you're having an argument with a friend and you over like whether or not a certain actor or actress was in a movie, and you look it up on Google. It's kind of similar to that, to set up that argument. So on March 1st, the Fifth Circuit issued its ruling, and that was mostly bad news for the NCAA. While the court did give the NCAA a little relief in allowing it to exclude from discovery any documentation of possible injuries not caused by blows to the head, the original discover order issued by the trial court stands on all other points. Attorneys for Ploetz will have access to documentation of any such injuries in all NCAA sports going back to 1950. That's 67 years worth of documents, mostly internal communications between employees of the NCAA about possible injuries sustained by blows to the head in any of their sports. That's American football, that's real football, or what's more commonly known in this country as soccer. That's ice hockey, possibly field hockey, a number of potential NCAA sports could be involved in this. So why could this be bad for the NCAA? On top of what could possibly be revealed by the documents obtained in discovery, there's the trial itself. It's the first time that a case revolving around CTE will actually go to trial if it gets to that point. That's what is kind of big from a legal precedent standpoint, is the fact that, for the first time, CTE is going to be the focus of a trial. Prior to this, there had been, like, the NFL concussion lawsuit had CTA involved, but the settlement allowed them to kind of skirt that issue. Other CTE lawsuits have been settled out of trial before the trials happened, which is still a possibility in this case as well. But if this does go to trial and the trial is seen through, a court is going to decide whether or not the NCAA is liable for deaths of former athletes who are diagnosed with CTE post mortem. Now, as I already mentioned, a trial could still be avoided in this. It's ultimately the job of Ploetz's attorneys to get her the best deal possible, and a settlement may be that. However, while a settlement would allow the NCAA to avoid the potential bad story of a trial and any negative information that could be revealed in the course of that, it's not necessarily all sunshine and rainbows for the NCAA to settle this case either. The reason being is because if the NCAA settles this case, that opens the door to many other people in Debbie Ploetz's situation who are a family member of a deceased NCAA football player, NCAA ice hockey player who has passed away and been diagnosed with CTE post-mortem, to bring similar suits against the NCAA and expect a similar settlement. And the NCAA does not want to get into the business of writing checks to family members of former athletes who have passed away and been diagnosed with CTE. There may not be that many of those individuals out there, but the settlements could be large in terms of value. And so that's why the NCAA doesn't want to get into that habit. Another reason why a trial would be a bad situation for the NCAA, and perhaps more motivation for them to settle, to at least offer a settlement, despite the can of worms that might open for them, is because the Fifth Circuit Court also lifted a stay that the trial court had placed on the deposition, which means an interview under oath, of the NCAA's chief medical officer, Dr. Brian Hainline. What could be revealed in his testimony about the NCAA's stance on the connection between American football or any other sport and the development of neurological disorders could be damaging for the NCAA as well. Under deposition, Hainline would have to navigate this narrow path of appearing to stay aware and on top of the latest research regarding head trauma and neurological disorders, while at the same time not giving any ammunition to Ploetz's counsel. So that is another thing for the NCAA to consider when they're going to, when talking to their counsel about what to do here. If no settlement is made, this case is going to go to trial sometime next month. We don't have a definitive date yet, and we'll see what emerges from it if it does. Sports law junkies like myself are hoping that it does go to trial, just because of all the news that could come out of it and the precedents that could be set in such a trial. However, as I mentioned before, I completely understand that it's the job of Ploetz's attorneys, and what she's seeking in this case is not necessarily to change the legal landscape or expose the NCAA, if that's something that this case ends up doing, but to get paid for the damages that she believes she's entitled to. And so a settlement may be in her best interest in there. But either way, this case bears watching, and I will be staying on top of it as it unfolds. Thanks for watching. I'll be back soon with more sports business and sports law information for you.